Good morning. I'd like to declare the January 29th New York City Campaign Finance Board meeting in session. We have minutes from our January 18th meeting, I believe. I believe we're going to recommend one correction on those minutes. Amy? Excuse me, it's the January 10th meeting.
Yes, actually the correction is for, actually have two sets of minutes, one for October 18th and for 2012, and one for January 10th, 2013. The correction is in the October 18th minutes that were distributed to the board. The correction is in item number 15, in the description of Mr. Davis's statement, in the second full sentence, it says we're making a payment for services that weren't designed to benefit the campaign. It should be instead of were, it should be were. And then the next sentence it says there are four extra words. The campaign finance board proceedings is just garbled. It should just be stricken. And then the minutes will be correct.
Okay, any comments, board members?
So moved and
Okay. Second. All in favor? Aye. The chair would like, I believe this will be our final meeting here at New York Law School as we return to 40 Rector for our next meeting. So on behalf of the board and the staff, I would like to thank New York Law School for their great hospitality to us over these last several months. Report from the Executive Director, Amy.
Just a couple things to announce. Since our last meeting, we had the January 15th filing. We had about 155 cabinets file disclosure statements across 3 election cycles. There is a special election scheduled for February 19th in Queens. And finally, yesterday we held our debate breakfast, which is the initial event for people who want to be sponsors for the debate program. It was very, very well attended. Almost 100 people attended. So we hope to have a very healthy competition for debate sponsors for the 2013 election.
Thank you very much. There'll be no report from the Voter Assistance Advisory Committee today. We now have candidate appearances. Is Melissa Viverito here?
My representation.
Are you waiting for the candidate? Or?
We expected her here. If you'd like to give
we have other people too.
Yeah.
We're going to appear, so we want to wait. We can wait.
Okay, we'll wait for a second call. Thank you.
So, Brad Ladner?
No,
He's not. Okay, so we also have a couple of petitions. Kendall Stewart.
Would this desk be suitable?
Good morning, Mr. Stewart.
Good morning. My name is Brian Pachasarli. I'm counsel to Dr. Kendall Stewart, Councilmember Stewart. We'd like to thank the board for their time to meet with us. Our petition goes singularly to the November 15th final determination by the board. More specifically, it goes to the public funds calculation, which is on page 4 of the determination. The board states that the board further determined that the campaign's coordination in alleged independent expenditures, the use of an entity owned, I repeat, owned by Stewart, to conceal from the board expenditures in furtherance of the campaign, and the campaign's failure to participate in the audit process constitute a breach of certification. The entity that we're referring to is the Wesley McDonald Holder Regular Democratic Club. The Democratic Club, by its definition, is a not-for-profit organization that does not have any ownership. So the word ownership in that regard is an error. I have for the board's review the bylaws of the Democratic Club if they are so inclined to see them. If you could please turn your attention to page 2. I have 2 highlighted paragraphs. The first being Article 1, Section 7, states that the vote of a majority of the Board of Directors entitled to vote if a quorum is present at such time shall be the act of the member. Action without a meeting may be taken, setting forth the action so taken when so ordered by the state committeeman. Number 2, the second paragraph is Article 2, Section 1. The corporation shall be managed by its board of directors. The number of directors constituting the entire board shall be 11. Again, Dr. Stewart is not the owner of the club. I rest my case.
Okay, any questions?
Putting aside any other procedural questions that we may have about the petition, are you aware that the treasurer of the campaign appeared on November 15th?
I'm not.
Are you aware that the treasurer of the campaign said that when he appeared that he discussed the fact that he would hear with Kendall Stewart, and that Kendall Stewart was aware there was a hearing on November 15th?
Can I have some clarity to as who the treasurer is? There's some factors in this where the treasurer has...
Mr. Daniel.
Mr. Lennox Daniel, that is correct. Okay. I am not aware of those circumstances.
So, are you aware that he was specifically asked whether he was offering any defense to the allegations of improper coordination, and he said no?
To the improper coordination and to such allegations, I'm not sure that Lennox Daniel had the wherewithal or the information necessary to make such a defense. He was instituted as the treasurer after the campaign had finished. I'm not sure he has intimate knowledge of what the campaign structure was, or if there was any coordination whatsoever.
Mr. Kendall Stewart was aware of this and never bothered to come to hear.
My understanding is that Kendall Stewart was, after he was elected, he got very sick. He had multiple heart transplant surgery, and that he was out of the state at the time of the hearing.
Are you aware that one of the key pieces of evidence as to improper coordination is the fact that the Wesley McDonald holds a regular Democratic club actually paid the salary of Mr. Daniel?
I'm not aware of that.
And are you aware of the fact that the check for that payment was signed by Mr. Kendall Stewart?
I don't have any other documentation to support that.
And Mr. Stewart is not here today.
That is correct.
And as far as I'm aware, we haven't received any sworn statement from Mr. Stewart in defense of the allegation.
I'm not aware of any such statement.
I know.
Thank you.
Thank you. Okay, thank you very much.
Thank you very much.
We have another petition. Lapia, present. Okay.
Yes, I'm actually waiting for co-counsel on this matter.
Sorry, I did not hear this Lapia, sorry.
I'm Bianca Perez, I'm waiting for my co-counsel, Leo Glickman.
Okay.
We have a
All
second
right,
call.
so we have who else do we have here?
That is,
I have a candidate here.
the candidates, you're waiting for your co-counsel.
That's correct.
We actually,
I will give we can wait 5 minutes, okay, and then we have to move on, because you know what time these sessions are supposed to start.
Thank you.
Okay, can we please invite up Udelka Tapia and council? Thank you. Okay, please state your name.
Good morning. I'm Leo Glickman, and I just would like to apologize. I saw that there was 4 appearances for penalties and fines, and I just didn't think we'd be starting at this time. So I do apologize to the board and to everybody here who's had to wait for me. So I'm Leo Glickman, and I am the attorney for Udelka Tapia's 2009 campaign, and each can introduce themselves.
I am Udelka Tapia.
I'm Jorge Javier, treasurer of the campaign.
I'm sorry, I didn't get that.
Jorge Javier,
Jorge Javier.
yes.
I'm Bianca Perez, co-counsel to Mr. Glickman.
Okay, please let me know how we proceed.
Okay, yes, I think we've submitted our petition, an explanation for our with respect to the public funds repayment. And in a conversation with Mark Griffin, he had prior to this, of course, he had told me that the issue really to address here is the cause issue for not having submitted the documentation. Obviously, we'll answer any questions you have about documentation, but we're really here to, at this point, to just make a presentation about the cause issue on why we could not get the documentation to you earlier. So I'm going to ask Mr. Jorge Javier and Ms. Udelka Tapia both to speak on that issue.
Proceed, please.
Okay. Well, so I'm the treasurer for the campaign. Udelka Tapia is also my mother. So aside from being the candidate son.
Can I just get a little closer? I'm having trouble hearing.
Yes.
Just a little bit louder.
Okay.
Maybe if it's the mic, I'm sorry, the microphone is that little round thing there, so maybe you switch seats.
Okay. Great. So I'm the candidate son. I was also the treasurer, and in 2009, June of 2009, I rejected. I have end-stage renal disease, kidney transplant, and in June of 2009, I rejected kidney transplant and went back on dialysis. And I'm currently still on dialysis 3 times a week, and really what I'm trying to explain is that part of the delay and all the non-compliance in terms of the financial reports and things of that sort were related to my coping essentially with the pressure or all the things, and there were obvious lapses in judgment and things like that, but really it's a case of mistakes being made because of the illness that have had to cope with, and that was unanticipated in many ways, and kind of like our family dynamic was affected by. I mentioned some of these things in the letter that I submitted, and ultimately we always intended on resolving these issues, but of course, it reached a fever pitch, and we're here now. But essentially, that's the explanation. That I was a treasurer, and I was severely ill for a portion of this time, and it took its toll and prevented me from fulfilling my duties.
Okay. Thank you. Any other comments?
I'm Udelka Tapia, and I was a candidate. And it was, I know that it was a lack in judgment when I asked my son to be the treasurer. I being in the community for so many years, raising 4 sons in the community, make me a little bit skeptical of putting somebody that I wouldn't have the complete trust without knowing how all the paperwork and all the work that actually that position and the responsibility that it comes with it makes me do that. But trying to get somebody that I trusted, that I wouldn't betray the campaign because it had happened in the past, and I make that lacking judgment in appointing and asking my son to do that responsibility. But as he got sick, he's been sick for a long time. I had 3 of my sons suffer from kidney disease, of my 4 sons, and he had a transplant. He lost a transplant in 2009, and he went into really deep depression after that. I mean, he thought that he was well, 20 years old. And of course, as a mother, I had to tend to my family first. And that's what I did. Running a campaign is a big thing that you don't know it until you are part of it, and all the things that come to all the withdrawal. When you lose a campaign, and then the whole family have invested in that campaign. My whole family was in that for us, because my life is being in the community. They know how passionate I am about going to the community and doing and giving back to the community, because I had to raise my sons by myself. So that's the way I did it. I did it with the community. And my family invested everything that we had in that race. And when we finished the campaign, my son was really sick, going to dialysis 3 times a week, to the emergency room also several times during the life, to psychiatry thing because of the depression that he went. My husband lost his job. We were completely broke. I had to come and be there and support my whole family for all these years, all these 2 years, 3 years. I didn't have the capability myself of doing that job, of submitting those reports. I didn't have it. I didn't know how to do that. It was costly to hire people to do it, but mostly it was because I have to go and support my family all these 3 years, and it took a toll on us, and definitely we're here because we actually want to correct what was wrong, what we did wrong, and take the responsibility of submitting. There was no wrongdoing in the campaign, and that I know because I am a woman of integrity, and I know that. And I'm here because I want to do the things right, and I don't want to make the same mistakes that we did. And that's the reason why I'm here, asking for you to take into consideration all these things that doesn't make the things okay, but that's the reality that I lived during these last years with my family. I also have to take the responsibility of raising a grandson that it wasn't on my plate. ACS called me to take responsibility of my grandson, otherwise they were going to put in foster care, and I had to take full custody of my grandson in December 2009. And that was another thing that was added into the plate of the family, and my other 2 sons being sick too. I think I am not making the excuses. I don't think that I'm making the excuses, but this is the reality that our family lived for these past years.
Thank you very much, Delta.
Just for a moment. We're here talking about the public funds repayment. I just want to remind the board that this campaign is being fined almost $16,000 for not responding to the draft audit report and to the request for documentation. This campaign is being fined $2,250 for not submitting, bank records and merchant account records. So it's being fined $700 for not documenting receipts. It's being fined $20,000 for documents that we've now submitted, albeit untimely, with respect to alleged over-the-limit contributions. And when you have the documents, you'll see that those contributions were not over the limit, though you didn't know that when you assessed that penalty. I say this all to you, that this is not a campaign that's asking not to be punished, not to be fined for its transgression and its untimely response to the draft audit report. It's simply asking that you review the public. Your mission to review public funds is to make sure that they were spent and spent appropriately, and that you give her that opportunity to show that in fact public funds were not misused. Public funds were spent appropriately, spent in furtherance of her campaign, which is what everybody's here to do. On that, we rest on what we just said and what we submitted to the board.
Thank you very much, Mr. Brooklyn. Any questions?
And obviously we heard, and the issue that the board has to think about is $78,000 worth of public funds, and that in 3.5 years or 3 years, there was never a response to any request, and never anybody showed up at any penalty hearing or anything. So that's the kind of thing we have to factor in terms of the system that we will discuss.
We understand that, Board Members, Mr. Davis. We just asked that you also consider that we will pay fines and penalties for that as well. So,
okay, thank you very much. We now have Melissa Mark Viverito, come forward, please.
Not a problem. Not an issue. Good morning. Good morning, Father Parks, Executive Director Lopez, members of the board, Mr. Bishop, Mr. Pitta, and Councilwoman Mark Viverito. Before the board is a matter of the Viverito 2009 campaign. Staff recommends that the board find that the campaign committed 3 categories of violation of the Campaign Finance Act and board rules. The violations are 1, accepting over-the-limit doing business contributions, 2, accepting over-the-limit contributions, and 3, exceeding the expenditure limit.
Thank you very much. Response?
Good morning, Father. Good morning. Good morning. We've noted our appearance, but it's Robert Bishop of Pitta Bishop, Del Giorno, and Giblin on behalf of Melissa Mark Viverito. Viverito 2009 is the actual client. I'm joined by Councilwoman Mark Viverito and by my colleague Vito Pitta. My name is Bob Bishop.
We've narrowed down the issues, I believe, with staff, that we have one contested issue, and that's the third issue on the over expenditure during the primary season. The other two issues we're not contesting. This really comes down to the definition of reasonable, which is not in the guidelines, it's not in the statute. If I go back to my early education, maybe we had courses in what constituted reasonability, but here the question is what the campaign done reasonable? So is it reasonable to have a website? It's only two answers possible, yes or no. We say yes, it's reasonable to have a website. Is it reasonable to have a website for the primary? Again, we say yes. Is it reasonable to have a website for the general election? We say yes. Now, the timing of the decision as to when you're going to have a website for the general election is made fairly early. It's made before you even know if you're going to have a general election. It's made sometime, well, in our case, in the spring of 2009, but you know that you're going to have a general election at the earliest in mid-July of that year, when other parties would file petitions. And in fact, it can be somewhat later if there are right-to-ballot petitions filed or independent party petitions. So you don't know if you're going to have a general election until you've done your planning on having the website. So again, you cannot and do not want to go into a potential general election without a website. Therefore, we say, yes, it's reasonable to have a general election website. You know, reasonable is so many different things to so many different people. We asked for an adjournment. I promised Danny I wouldn't dwell on this too much. On when we heard from the board's final decision Thursday night, Mr. Pitta knew that I was going to be in Albany till late last night and had asked for a website, but an adjournment. But you know, it was not reasonable for us to have it. And you know, in fact, Danny's judgment was reasonable because I had a great ride on the train this morning and saw things along the Hudson River that you don't get to see unless you're there at 6 in the morning. So different viewpoints of what's reasonable. I'll recover my reasonability later on in the day.
I have a reasonable question.
Yes, sir.
When did the website go up?
The website actually went up in August, actually July. And what we're talking about,
Do you know what exactly?
we're talking about a redesign of a website that had been in place since 2005. So if you go to the Wayback website, you'll see that in 2005 through about 2009, it was a much more simplistic website and was not, very sophisticated. The web design by Somos Arte brought it up to 2009 standards, and that was around mid-July, I guess it went live. Based on the statistical analysis that we presented to the board, we show no web hits in June. We show a minimal number in July. Now, I'm just jumping ahead of myself a little bit on that, but if you look at the website now, it consists of HTML code. I'm not a great computer whiz or anything like that, but this type of opportunity affords me the ability to look into things. So a typical page, there's 5 main pages of this website, has 472 lines of code. The code that's actually related to the primary, that's only related to the primary and to nothing else, is about 44 lines of that 742 lines of code. Of those 44 lines, about 40 of those are for something called metadata, and it does not show up to the casual visitor. So if you look at the website, this is the website as you bring it up on your computer, but the actual page is 3 feet long, and the reference to the primary is this little dark spot at the bottom, which is about 1/2 inch out of this 36 inches. It says primary day September 15th. Now that's still on this website because of a dispute between the designer, who we paid all the money to, and the campaign. They said that they took the position that after the primary day, to change that component of the site would be new artistic work, new developmental work, and they wanted to charge us more than the existing contract. So we paid the contract. Half of the payments roughly were made after primary day, so that we could do other updates. And you can see from the website there are other updates that were included. But the template had a top graphic with a nice photograph, and it had a bottom graphic. And rather than split that graphic, nobody at the campaign really had the technical knowledge to do that. And I think if I get to stay with this a little bit longer and they give me access to it, I could probably do it. But that's neither here nor there. You usually have a commissioner that's quite a bit of knowledge. I was hoping he would be here and tell me how to do this. But in any event, if we look at the 6 weeks immediately before the primary and the 6 weeks before the election date, and by the way, the lines of code, I mean, they print out to about 16 pages, and I've highlighted the references to the primary day here. But if you look at the hits or the individual visits before and after the primary, you'll see that on distinct visits to the site, which could be duplicate visits from a person. In other words, Bob Bishop could go and visit it twice. I don't have sufficient statistical analysis to say, geez, was it Bob Bishop? Was it Father Parks? Was it Danny Frost? But I can say that there were individual visits at different times, different days. You'll see that, and this is the information which we gave to staff, that 61% of the visits occurred in the 6 weeks prior to the primary, and 39% occurred between the primary and the general election. After the general election, it goes down. The highest number of hits on that website was actually post-primary, the day after the primary. I presume people trying to find out what the results were. And of course, those are not on this particular website anyway. But in any case, the campaign staff, and I quote from their latest response, does not dispute that some attribution of website costs to the general election period is reasonable. Now, we spoke to the staff. We said, if not 50-50, what? 45-55? And they told us, no, we can't give you that kind of guidance. I wouldn't be here making the argument if someone on the staff were empowered to say, geez, Bob, that's about 40%. Can you settle for 60-40? And, you know, that particular definition of reasonable is really left to the board here. You know, we make reference to Board Rule 1.08b, making clear that an expenditure for services is made when the benefit of services is received. So the fact that we spent roughly half before primary and half after primary, that timing of the payments is not really relevant. It's whether there was benefit. Now I assert to you that there is benefit. A candidate gets their mandate from the people based on the general election. This general election we call uncontested. This candidate received 68% of the votes cast at the general election. There were what we call blanks. There were 24,156 total votes cast, 17,000 for Melissa. She would like that number to be 24,000. Without an outreach on the general election, the number of people that are going to vote for you goes down, and your appearance of mandate, your statement of public mandate diminishes as well. Again, we get back to the question, is it reasonable to have a website in the general election? And I assert that it is. So in quick summation, I don't want to keep you all for much longer. We truly believe that the 50-50 allocation is reasonable based on the simple question, do you need a website before the general election? And the answer is, of course, yes. What I think is not quite reasonable is for the campaign finance board to come back to me and say, Bob, 50-50 is not a reasonable number, and for them not to be able to suggest to me what is a reasonable number. Again, my statistical analysis shows roughly 60-40. And, you know, no matter how I massage the statistics, whether it be by hits or by visits and individual visits, that 60-40 number keeps coming back to me. And we're talking about percentage of the total expenditure on the web here. Do I have... All right, so I've got nothing further to say. Certainly, if there's questions, I'd be glad to try and show off what little knowledge I've acquired about web stats.
Thank you very much, Bob. When did you study philosophy?
Fordham.
Okay, good.
I had about 9 years of...
Do I now? Because, good. I knew that was a good thinking definition there. Danny, responsible.
Staff does not dispute that a campaign may have a website for a primary and a general election. We don't dispute here that some attribution of this expenditure to the general election is appropriate and reasonable under the circumstances. But the board's longstanding practice is not for staff to determine an attribution for an expenditure between two election periods. This practice is for the campaign to propose an attribution supported by adequate documentation. In response to the draft audit report, the campaign proposed this 50-50 attribution. In its penalty notice, staff said, frankly, this attribution is not supported by documentation. Why don't you go ahead and propose a new attribution supported by new documentation for the staff to consider? Rather than propose a new attribution, the campaign maintained that 50-50 is reasonable, and we would simply submit that the documentation submitted so far does not support a 50-50 attribution.
Thank you, Danny. Questions?
Yeah, let me ask a question. I feel surprised that do you have a view? I mean, in other words, we're here in our adjudicative role.
I'm sorry, I can't.
We're here in our adjudicative role. Do you have a view? I mean, what do you think, as you're sitting here now, do you have a view as to what the criteria should be, accepting the fact that there has to be some allocation between the two?
Sure. Staff believes that the web traffic statistics submitted by the campaign are relevant. We don't think they're dispositive. We certainly don't think that they reflect clearly a 50-50 attribution. The board has also, in previous cases, held that the actual benefit, pursuant to Board Rule 108B, the actual benefit of a website is received when the vendor has completed work on the website, when the campaign has the deliverable of a website that's ready. That's what the board determined in the Fierick case. But again, staff does not dispute here that the traffic statistics do indicate that some attribution is reasonable. Had the campaign proposed an attribution of the sort that Mr. Bishop now proposes, and staff had time to analyze whether the documentation supported such an attribution, we would have. However, until today, we were evaluating the campaign's proposed 50-50 attribution.
Thank you, Danny. Any other
So you don't have an affirmative position?
It wouldn't be staff's practice to come up with one on its own.
We did seek guidance of the staff as to what would be reasonable, and we're quite frankly left in a position of negotiating against ourselves if we move off the 50-50 position without any hope of a response. So it doesn't do me any good to propose anything less than 50-50 to staff is basically what their response was to me, because whatever I propose, they would not say, okay, this portion of the complaint is resolved. So I'm left to make that proposal here.
On the primary, you said 6 weeks. Why did you eliminate July?
July was mostly testing of it, and it really, if I eliminated July, I also eliminated December, which would be after the whole election process, and I eliminated the balance of November. When I add in July, the numbers are really indistinguishable. It makes maybe a point difference.
I thought we added July, which is 50,000 hits in July, but that these numbers
when I add July, it really didn't make much statistical difference, and I thought it would be fairer to compare 6 weeks before each election cycle, because that's when you start to get actual hits from the public. A primary election in New York, I could make arguments that Labor Day until primary day is what counts. So I decided to go with 6 weeks on both sides. But as I say, statistically, it doesn't make a huge amount of difference.
Thank you, Bob. Any other questions? Okay, thank you very much. You know our procedure. We go into executive session. We have one more candidate, and then after session. We'll now finish the sessions. Thank you very much.
Thank you.
Thank you.
And now we have Lander. Please. Okay, could everyone please introduce themselves, beginning here?
Good morning, Chairman Parks, Mr. Davis, Ms. Lopez, Mr. Piazza. I'm New York City Council Member Brad Lander, and this is my treasurer and wife, Meg Barnett.
Good morning, Father Parks, members of the board, Executive Director Lopez, Councilman Lander, and Ms. Barnett. My name is Danny Frost on behalf of CFD staff, and with me is Allison Levy, Senior Auditor. If I may proceed, before the board is a recommended violation for accepting in-kind contributions. Additionally, staff recommends that the committee be required to repay public funds in the amount of its final bank balance less incurred liabilities or qualified expenditure deficit, whichever amount is higher.
Okay, response please.
Thank you very much, Mr. Chairman and members of the Campaign Finance Board. Thanks very much for the opportunity to appear before you this morning. Both Meg and I are strong supporters of the New York City Campaign Finance Act and the board. I was proud to work with the Brennan Center, where Meg actually previously worked on an amicus curiae brief in Ogden v. Parks in support of the act. Sure, and I can, yes. Okay. I apologize. Thank you. I'm a little nervous. I was proud to work with the Brennan Center, where Meg previously worked on an amicus brief in support of the Campaign Finance Act in Ogden v. Parks. Last year I sponsored a resolution in the City Council calling for repeal of Citizens United, and I'm actually currently working with other local elected officials around the country through a nonprofit organization called Local Progress, on whose board I serve, which uses New York City's Act and board as a model. We have great respect for the CFP staff, who have been extremely helpful to us on countless occasions. While we disagree with their recommendation on this case, we really do appreciate their diligent work to keep the city's campaign finance system effective and transparent. We work very hard to comply with all the rules and regulations for Brad Lander for City Council, the 2009 campaign, and are extremely proud of the fact that outside of the contested issue regarding data and field services, there wasn't one single other violation found in the campaign's compliance. Most of the credit for that goes to Meg, to be sure. We appreciate that there's broader policy issues in play here, which attracted substantial public attention about coordination and especially what types of communication and coordination are permissible between candidates and political parties and other endorsing organizations and vendors. And of course, if the board chooses to promulgate new policy in this area, we would follow it to the hilt. But the question here today is whether the campaign followed the rules, and I really believe if you look at the evidence I'm going to ask you to in just a minute, you will see clearly that we did. For some context, the CFP conducted a truly extensive investigation of the campaign over 4 years. There were 2 visits by CFP staff to the campaign office during the election cycle with full access to all records and staff. We complied fully with 4 requests for extensive documentation, mostly related to the data and field services in August and September of 2009, in March and June of 2010. And in addition, the CFP had access to all relevant campaign email correspondence pursuant to a United States Attorney's subpoena, something I think that's pretty rare in a campaign finance review. This was an extremely thorough review, which we welcomed as strong supporters of the campaign finance system in this situation. We're proud of the fact that this review essentially vindicated our compliance across the board. Out of that very thorough investigation, the only violation being alleged in the notice relates to 5 emails between April 1st and May 15th, 2009, which we ask you to review in detail, and they're attached to the testimony, and they were also in the notice of violation. Some of these 5 were sent prior to the effective date of the campaign's contract with Data and Field Services, but contrary to what the staff has alleged, they simply do not show the provision of any valuable service prior to the campaign's effective date. Now, because they're the full extent of the alleged violation for a $7,500 penalty, and because our response to their substance wasn't addressed in the staff's final recommendation memo to the board, I'd like your permission to go through them in detail, and they are attached as Exhibit 1, so if you don't mind taking a look at them while I go through them, it would be very helpful. The first, dated April 1st, 2009, from Rachel Goodman to Meg, makes clear that financial management in the period prior to the contract would be performed by Ms. Barnett in her role as treasurer, who was acting as a volunteer, and not by DFS or WFP. That email did include the transmission of a very simple budget template with a few numbers filled in, but those were drawn from CFP data. There was no analysis performed. It wasn't a proprietary product, and it didn't involve more than 5 minutes of work. And it's not evidence that Rachel Goodman or Emma Wolf maintained any authority to set the campaign's budget, as the staff memo alleges. Quite the contrary, it makes clear that Meg had that authority throughout the period prior to the effective date of the contract, which she did. The second two emails, dated April 16th, 2009 and April 27th, 2009, simply invite me to interview and approve the contemplated campaign manager, whose services were exactly what was going to be provided under the contract between the campaign and DFS. So I don't believe that these two emails, if you look at them, reflect any valuable service. They're simply a negotiation about the very services that were covered by the contract that we were preparing to sign. As an analogy, if you consider renting a copy machine, before you sign a contract, you have a lot of dialogue with the salesperson about the various options. That's not an extra service. It's part of the negotiation in advance of a normal contract. I was contracting for DFS to provide me with an excellent campaign manager, and I think it was entirely appropriate to communicate with them about the process of hiring and who that campaign manager was going to be. The fourth email, similarly dated May 7th, 2009, again from Rachel Goodman, reviews the standard job descriptions for the positions which we were preparing to contract. Again, it's clearly a conversation to clarify the provision of services in the contract that we were preparing to sign. The final recommendation to the board here actually calls out one of the sentences here: all the work of the campaign manager will be supervised by me, as evidence of Rachel Goodman's authority. But if you look at it in this email, you'll see quite clearly it was a statement about the authority she would have once the contract was in effect, which we fully reported, which we fully paid for her time from that point forward. It doesn't reflect any authority prior to the campaign, to the contract period. And the fifth, May 15th, 2009, which is on the back, is simply the email that contained the final contract, covering and documenting the fully disclosed and reported expenditures for campaign management services, which I think was exactly what we were supposed to do. That's the full extent of the alleged violation in the notice of violation and the staff report, these 5 emails over 6 weeks. And so I ask you to consider closely, first, do you believe they constitute any meaningful, valuable service prior to the contract? And I think it's clear that they don't. And second, even if you believe that somehow they have some small quantifiable value, do you really believe that these 5 emails, coming out of the full and extensive investigation that was conducted of the relationship between the campaign and DFS, merit the very high penalty of $7,500? And again, I believe it's clear that the penalty is excessive, and I ask you to consider eliminating or reducing it. The second issue here is the finding of the staff that the canvas and door knocking work performed by data and field services under a separate contract, there were 2 between them, totaling $37,100, was not an eligible expenditure of public funds. That work, the expenditures to DFS under both contracts, but in this case under the canvassing and fieldwork contract, were extensively documented with the documentation provided to the CFB, with contracts, invoices, and payroll records as required by CFB Rule 401D. And I quote I won't read it here, I quote here directly from the notice of violation: for wages, salaries, and consulting fees, candidates must maintain a contemporaneous record signed by an employee or a consultant. I'll skip the rest of the quote. We satisfied this rule by submitting the contract signed by both DFS and the campaign, containing all the information the rule requires for retained consultants, in addition to detailed invoices and payroll records. All that is at issue, for which the CFB staff is essentially proposing a $37,100 penalty, is that we submitted organizational payroll records instead of signed daily timesheets for the employees of this vendor with whom we had a valid and signed contract. This type of documentation that we provided was accepted as sufficient by the CFB in prior campaigns, as the staff memo acknowledges, and nothing in the rule or handbook clearly requires signed timesheets for the employees of a vendor. It is true that in August in 2009, the CFB sent communications to candidates about this matter, asking for those signed daily timesheets, but even these were somewhat unclear since they emphasize election day activities, and the campaign complied with that requirement for our election day and GOTV work. In any case, failure to comply with a mid-course change in documentation requirements issued after we had contracted for the services shouldn't be the grounds for a $37,000 penalty. Most important, CFB staff have not charged these expenditures to DFS. I apologize. Most important, CFB staff have not charged that these expenditures to DFS were not eligible services actually provided in furtherance of my campaign, and I believe that should be dispositive. These expenditures clearly meet the legal definition of qualified campaign expenditures, and the fact that the CFB found no deficiency in records for compliance purposes, I believe underscores that there's no significant gap in documentation, certainly not a $37,100 gap. If a record-keeping deficiency doesn't raise concerns about whether services were actually provided in furtherance of the campaign, then the record-keeping issue simply is not a sufficient basis for disqualifying those expenditures in their entirety. As a result, I believe that staff are misapplying Rule 108G for an arbitrary, and in this case draconian, result. Administrative Code 3-7042 is the statutory basis for treating expenditures as non-qualified, but because Rule 108 has no analog in the law, I believe the CFB should not seize on it as a pretext for wholesale disqualifications of expenditures for which these extensive records, contracts, invoices, vendor payroll records required by Rule 401B were kept, obtained, and submitted. The rule should be applied as a scalpel, not as an axe, and limited to situations where there's a significant gap in record keeping. Otherwise, the disqualification proposed here is tantamount to a $37,000 penalty for a minor record-keeping issue that doesn't actually raise a substantive concern. So I therefore ask you to consider removing or reducing the fine and eliminating or reducing the public funds repayment. Of course, in any case, we will return the final bank balance after expenses that's in the campaign account. I really do appreciate the time you put in as a board and all the hard work of the staff in maintaining a transparent and effective campaign finance system for the city, and I'm grateful for the opportunity to present.
Thank you very much, Councilman Landa, for your presentation. Response, please.
The services associated with providing a budget, recruiting, interviewing, hiring nominal in-house campaign management, these are valuable services. And the services were so valuable that the campaign began to pay these individuals for providing similar services once the contract became effective. Now, the campaign maintains that, these emails were prior to the effective date of the contract, which staff also believes, although I would note for the board that although the contract is dated May 7th, staff has reason to believe that the contract was entered into much later, and in fact the campaign has represented previously that these individuals did not begin working for the campaign until June. It's not reasonable to argue that they were acting in a volunteer capacity during the time that these emails capture, and then once the contract became effective, they were acting in a paid capacity. The rules simply don't permit that arrangement. The email dated May 7th, quote, all of the work will be supervised by me. Staff believes that this email places the previous emails in context to show that the services being provided were important and valuable services in truly setting up this campaign. As far as the amount of the penalty, it simply reflects the seriousness of failing to account for in-kind contributions in the context of our statutory scheme, and we believe it's also appropriate here because the campaign failed to report or pay for these services, consequently they came in just under the expenditure limit. The board has already penalized two of the candidate's opponents in this race for exceeding the expenditure limit, and we believe that the penalty addresses that issue as well. With respect to the documenting the qualified expenditures, we're not aware of any mid-course change in rules. Board Rule 401D was promulgated in advance of the election. It was applicable to all candidates in the election. And it says, quote, for wages, salaries, and consulting fees, candidates must maintain a contemporaneous record signed by the employee or consultant and the campaign and dated, providing a detailed description of the services, the dates on which the work was performed, the period for which the individual was retained, and a detailed breakdown of the numbers of hours worked. The payroll records submitted by the campaign clearly lack this information, and therefore CFP staff determined not to qualify these expenditures.
Thank you, Danny. Questions from the board?
Thank you. So a couple of things. On the question of the dates, I think if you look at the last email, you'll see quite clearly the effective date of the contract was May 7th. This email is dated May 15th, and what it reflects is that Meg is saying, hey, where's the contract? And Nancy's already started working. So I think it's pretty clear the contract effective date was May 7th. The contract was dated for May 7th. We were asking to get the copy of it for our records May 15th. She had started work after May 7th. So I don't know where the other information came from. We're certainly not alleging that we're acting as volunteers in these emails. I just would ask you to look at the emails. We're not alleging that they were acting as volunteers. What we're saying is we were negotiating a contract, and that is what these emails reflect. They simply, the question isn't were we in dialogue with them. The question is were they providing a valuable service? And if you're preparing to contract with people to provide a campaign manager, then getting to interview that campaign manager is appropriate. And if they're going to have job descriptions and there's going to be a structure of supervision, you ask questions about it. But how could we sign a contract otherwise? So this is the full extent in the notice of violation of the alleged unreported in-kind contribution, and they just don't show it. These emails, they're perfectly appropriate. I don't believe they show any valuable services that should have been reported. We did stay under the limit. And then on documentation, I quoted the same section because I believe we did provide all that. We did maintain a contemporaneous record. The contract was signed by the consultant and the campaign. The payroll records are dated, and they contain a detailed description of the services. They meet the rule 401D. All they don't have are signed daily timesheets instead of payroll records off a signed contract. They are detailed and contemporaneous. I don't believe anyone thinks that what that money went for was anything other than paying the wages of canvass workers employed by DFS. Their names are there, their identifications there, the amounts paid for them are there. So at most, it's a very minor record-keeping issue on an expense that I don't think there's any allegation wasn't entirely qualified and appropriate. To disqualify in its entirety $37,000 is unfair.
Thank you, Councilman.
I have a question. How do you explain the fact that the April 1st of 2009 email seems to indicate that Rachel released all information on the campaign and reviewing the amount of money spent, preparing a budget worksheet, making entries on the budget worksheet, and holding a meeting at which Meg was nominated to keep an eye on the budget?
We were in...
Does that show that they were working on the campaign at that time?
Well, I think it shows that Meg was in charge of so we were absolutely in dialogue with them. We were in dialogue, and look, part of the issue here, and I appreciate that it's the issue, is that we were in dialogue with them in their capacity as Working Families Party, who had already endorsed my campaign at that point, and we were in dialogue with them in negotiations to prepare for DFS to be the vendor. I appreciate that raises a broader set of questions that you've looked at and are interested in, and in another context, what the relationship between a party or an endorsing organization and a vendor is relevant, but that's not what's alleged here. So we were talking with them and meeting with them. We were preparing to sign a contract with them a month later from May 7th. That was when they began providing the valuable services of campaign management and field services. Well, field service contract began a little later than that, but the campaign management began on May 7th. This email says we sat down, we talked about what would happen when. Later we'll have there'll be a campaign manager who will be responsible. Until that time, Meg is the treasurer and she will do the work. So yes, we met and talked, and all the numbers, I'm sorry that the spreadsheet itself isn't attached. there's 6 numbers in it, and they come from the CFB. All she'd done was printed out the CFB website report on what the campaign had spent to date. For Meg to
Who invented those numbers?
the campaign. I mean, well, so
It was based on prior existing disclosures to the CFB.
So these are things that you invented,
They were things based on reports on behalf of the campaign, yes.
but you invented them.
Yes.
Into the spreadsheet or into the.
They were based on reports we had submitted to the CFB, and then that was on the publicly accessible database. They were the publicly accessible numbers.
there was a piece of work which Ms. Goodman did. So the campaign, mostly Meg, and had entered them into CSmart. They had been reported to the CFB. CFB put them up on the web. Rachel, in this instance, had downloaded them and attached them in an email. But I don't believe that shows.
In a template that they provided to say this is this is a form you would use to further track the budget. So the sending the template was what she did.
Thank you, Meg.
For us, I want to be clear. Other than interviewing for the campaign manager, which, as was pointed out, is going to be the person who's going to work with them on contract. That's conceded, is it not?
I'm sorry?
It's conceded that the contract will involve the campaign manager working with the candidate.
Yes.
So I'm putting that aside for the moment. There's a reference in one of these memos, the email records suggest daily conference calls and almost constant communication. But the only thing we've seen is this one other email. Is there anything else, any other service that's provided, again, putting aside the campaign manager, any other service provided?
Yes, I mean, the campaign, and staff is grateful for the campaign's compliance in this regard, has turned over voluminous email correspondence that do reflect what staff alleged in the penalty notice, that there were daily correspondence and calls. As far as the
about what substance? I mean,
right, as far as
pointed out, there's negotiation of the contract, things like
I'm
that.
sorry, I can't hear you.
As was pointed out, there's negotiation of a contract. So I'm trying to find out if there's anything else that is a service provided to the campaign that isn't interviewing the campaign manager and isn't negotiating the contract.
Well, staff reads, particularly the emails submitted to the board, we read these as evincing the performance of the same services that would begin once the contract became effective.
I'm sorry, I don't understand that because, again, most of them relate to hiring a campaign manager, which they're interviewing the person who is going to be the campaign manager under the contract.
Mm-hmm. Which we believe is a valuable service, as well as the budget work that's being done.
You don't think that's part of the contract to be involved in interviewing the
Well, I mean, frankly, we do believe that it should be part of the contract because that is the scope of the contract, but these services were performed before the effective date of the contract.
So your position is that because they're supposed to not have a campaign manager on the day the contract began, even though the contract provided that they would have the campaign manager on the day that the contract began.
To the extent that these emails evince negotiation with WFP and or DFS as to whether WFP and or DFS would become the campaign's vendor, which we don't necessarily view these emails in that context of negotiating a contract. We believe that the services had already begun to be rendered.
But these are the only emails you're really relying on in terms of provision of service.
Yes.
And I just want to make one point on the 37,000. I don't want you to overstate the case against you. That's not a penalty. The issue is whether it's a qualified expense and whether, and I think even the memo points out that there was documentation, but maybe not sufficient documentation. So however we come out, it is not a penalty. I don't want you to be.
And also, I mean, I guess on that same point is that, I mean, the rule is that the expenditures have to be documented. So there's also not, the fact that if the board determines that there's insufficient documentation, and I understand that your point is that there is it's not that they are not real services. I mean, otherwise you're right. There would be another penalty for something that were not proper services. There would be a different penalty for that, so that does not imply that either.
So just two things. I mean, a minor record-keeping penalty for I guess what I would say is that there is extensive documentation that I believe meets the rule. So a minor penalty for the documentation being in slightly different form might have been appropriate, but this will have, requiring us to return money which we relied on spending on a qualified, eligible purpose. To us, from our point of view, it's $37,000 we have to pay you.
Well, it's not. It's whichever is larger than the final bank balance. So you had 44,000.
This amount will be larger than the final.
You had 44,000.
That was prior to legal expenditures.
Less, but it's not. I assume there's still money in the bank.
We're looking forward to returning the final bank balance, and if we can satisfy this with returning the final bank balance, we will be delighted to do so. But we spent money, and we're going to have to come up with new money if these qualified expenditures aren't considered qualified. And one last small point: the sentence that you picked up about daily emails and correspondence comes in the draft audit report in reference to after the contract was signed. Not from the period before the contract was signed, and that was what we were contracting for. The staff asked some questions about that in the draft audit report. We responded, and those issues weren't raised again in the notice.
Just relying on these.
But that's my understanding as well.
What the bank balance is as of today, roughly?
30. It's my lawyer's here today, so it's around 30. It's 20.
Okay, thank you very much, Councilman.
Thank you very much. Thank you.
We now going to go to executive session. Correct? Penalties, and I will turn it over to Amy.
Okay. The first penalty the board has before it is the campaign of Stephen Levin, candidate for City Council District Number 33, accepting $250 for accepting an over-the-limit doing business contribution, $508 for exceeding the expenditure limit, a violation no penalty for making improper post-election expenditures, and $50 for failing to report a specific transaction for a total of $808.
So moved.
Second. All in favor? Aye.
Next is candidate Melissa Mark Viverito, candidate for City Council District Number 8 in 2009. $550 for accepting an over-the-limit doing business contributions, $125 for accepting over-the-limit contributions, and $1,547 for exceeding the expenditure limit, for total penalties of, I'm sorry, actually, I didn't do the total correctly, sorry. Total of whatever that total is. Sorry. I wrote the number twice, sorry.
Second. All in favor? Aye.
Next is the candidate Lynn Schulman, candidate in City Council District 29 for 2009. A violation of penalty for making improper post-election expenditures.
Second. All in favor? Aye.
Now, public funds payments. First is Brad Lander, candidate for City Council District Number 39, that the campaign be required to repay public funds in the amount of the final bank balance, less incurred liabilities, or the qualified expenditure deficit, whichever is higher. Qualified expenditure deficit is $42,365. The final bank balance as of the December bank statement was $44,991.
Second. All in favor? Aye.
The fund next is Stephen Levin, candidate in 2009 for City Council District 33. Payment of $23,254.02, which the candidate has already repaid. The committee has already repaid.
Second. All in favor? Aye.
Finally is Lynn Schulman, candidate for 2009 City Council District Number 29, a pay repayment of $6,129.72.
Second. All in favor? Aye.
Next, we have votes on the two 502A petitions.
See what? I'm sorry.
502A petitions. The first is Kenneth Stewart, candidate for City Council, in 2009.
Move to deny the petition.
Second. All in favor? Aye.
Next is candidate Hilda Tapia, candidate in 2009. Recommendation to deny the petition.
So moved.
All in favor? Aye.
Finally, the staff would ask the board to delegate to Father Parks the authority to approve public funds payments in the special election that will be happening on February 19th.
So moved.
Second.
All in favor? Aye. There being no further business, I will